Oh, yes, people. It has happened. Today is the day I got a haircut. Robert hasn't seen me yet. I should actually make sure we're live, but Robert doesn't know. We're going to see how it works in a suit and a tie with this fresh, what they call a skin fade in the industry. The AC is still not working in our house, so I have my sweat cloth for when it gets too hot. First of all, audio's good. Everything's good here. Let's see if we hear you clean up good. Anchorman reference is a classic. Yeah, Robert doesn't yet know that I've gotten a haircut, but I got a haircut, and they did this thing where there's like what's that called, a part, and now like I have to when I brush it, which I don't. It'll grow out of it. Yes. So how's everybody doing here? This is going to be an interesting live stream. There's a lot of good topics we're talking about. Until Robert gets here, let's go over the subjects. Breonna Taylor, Trump, the church versus Vegas, and the Sandmann settlement for all that we have to offer. There won't be much to add to it, but what was I going to say? Yeah, we hit 250,000 subs on YouTube, which is it's a freaking big milestone, and it's amazing. It's a milestone. The only next one that actually makes, I can see myself glistening. The only next one that makes a big difference in terms of a wall mount is 1 million. A hard part. Yeah, that's what seems to be what it's called. So I said I would surprise Barnes tonight, do this in something of a suit and tie. I do have my vlog shirt underneath here. I don't always fill out the shirt quite this much. And if it gets too hot, I might undress. And that will be a free part of the show. Okay, so standard rules. I do my best to get to the super chats, but there is no guarantee that I get to the super chats. Super chat is not a definitive way of getting into the conversation. It's a definitive way of supporting the channel. Until Robert Barnes gets here, I can do the ones that I see already. James Scott, is it possible to charge mayors and governors with something like non-feasance, malfeasance, or malfeasance, misfeasance or malfeasance? Robert will know, but I think the bottom line answer to that question, it's asked and answered, is there's immunity. It's virtually impossible, and that's it. It's an impossible thing. Let's see what we got here. Looking sexy, big man, Mr. Squirrel. Thank you very much. The sweat is going to be a hard turnoff for some. Haircut, you want to kill grandma. I don't know what that means, but it was the first haircut in a long time. And Larry Anthony, who was the one who actually way back when said, as promised, nice to see you dressed up for success. Congrats on reaching 250,000 subs. I hadn't even planned this out before reaching 250,000 subs, but the timing worked out perfectly. Minus the glistening. Now let me see if Robert is going to be in the house. I was DMing him. Here, let me just say this. Live now, warming up the crowd, comma. I'll bring you in when I see you, smiley face. So that's it. Let's see what else we got. A full of suit with no AC. That's Sullivan level crazy. Ugh. You can see the drips are coming down. We got Hi Viva, love your content. Thank you very much. JM Reed. Yeah, it's going to be a dripping, sweaty stream tonight. Okay. What else is going on? My goodness, it's crazy. It's crazy in this house. It's 34 degrees upstairs. Theoretically, could Congress do something about the federal forces deployed in Portland across the U.S.? I'm going to leave that to Robert. There's a lot of things I know that I don't know. I see a signal coming in. I'm not even going to waste time tonight bringing him because I want Robert to see.
You're decked out.
Robert, how you doing?
Doing good.
Look at this. We're wearing the same shirt and same suit, just a different color tie.
Exactly. Hey, great minds think alike. Great minds dress alike.
And like my grandmother always said, fools seldom differ.
Exactly. Indeed.
So I'm just doing some of the super chats while we're waiting. John Andrews says 250K woot woot closing in on that. Okay. I'll stop before the insult because I like the compliment. Thank you. And thank you sincerely. It's amazing. Actually, the last few days have been a big one. I think that latest Flynn video has really been getting some views and getting some new subs. So it's great. Robert, how are you doing?
Doing good. It's been a Yeah, it's definitely been an interesting time legally, and that just continues unabated as we see record-setting riots across the country in parallel there too. And so all of it is just it's fascinating. It's extraordinary. It's like watching these late '60s documentaries all over again.
You know what? I've always been meaning to ask you, for those who don't fully appreciate the reference that you're making, in a nutshell, can you explain what happened in the late 60s that people are analogizing to what's going on now?
Well, you really had a couple of parallel movements taking place. You had the generation of a new upper middle class in America that was really sort of new. That you'd had a professional class, you had wealthy classes, but we were mostly an agrarian society up until the 20th century, and then we had World War I and World War II and the Great Depression in between. And what came after that was extraordinary affluence, and also really the creation of mass culture. We didn't really have mass culture really until the 40s and 50s in terms of films and then television. So you had books and you had, but you really had a bunch of different cultures around the world, around the country, that is. And all of a sudden you started to create sort of a uniform mass culture that had its own influence. Universities, people had mass attendance at universities. Universities were a place where prep school kids went to kick off their heels back in the 30s. And then in fact, the way you used to make fun of people in plays in Broadway was you would have the idiot wear a Yale jacket in the 20s and 30s. So there was a Marxist professor, a labor, taught me that at Yale. All that changed in the 50s and 60s. Universities became a common phenomenon, mass entertainment and upper middle class suburban culture. And the children of that culture rebelled against it, rebelled against their parents, rebelled against neoliberal order, rebelled against all of it. A lot of them embraced Marxism. Others embraced different forms of radicalism. Started out as a civil rights movement in the early 60s. Feminism arose during that time period, late 50s, Betty Friedan and the rest. And it quickly took a radical left turn in the late 60s. And at the same time, you had the counterculture taking place in terms of music, in terms of drugs, in terms of lifestyle, in terms of rebellion against almost everything. And that fed the Weather Underground, which was originally the SDS, the Students for Democratic Society, when they became radicalized. And and you had people, if you go back, there's a great documentary on the Weather Underground, written mostly from a sympathetic perspective, but does do both perspectives well. And it exposes this mindset, that leftist violence was necessary to bring about the revolution. And so you had that, and you had parallel to it, you had people unsatisfied with what civil rights meant. Civil rights, Martin Luther King was on top of this before he was assassinated. The problem was essentially the civil rights movement started out in the African-American community as predominantly a professional class movement, doctors, lawyers, teachers who were limited in their ability to have a full economic market access. And so once the civil rights movement achieved that for them, but who were left behind were urban poor in the ghettos and the projects, and particularly those are communities that are already being abandoned by deindustrialization and manufacturing issues of jobs fleeing. They had come from the Great Migration from the South for those jobs during the World War II era, but by the late 60s, they were starting to disappear from cities. Political power was already restricted. A history of racist policing in those cities was sort of burgeoning up as an issue. And when civil rights didn't translate into a meaningful material improvement for their lives, it led to legitimate rage and anger. But parallel to it was the rise of a criminal class within the Black community, in part because of lack of opportunity for some, in part because there had been a long history of a sub-criminal class within the African-American community that Du Bois documented going back to the 1800s. And they co-opted a lot of the Black Power movements into a form of what we're seeing today in BLM is basically the Black Panther Party of 1970. What we're seeing in Antifa is basically Weather Underground and parts of SDS in 1968-69. They took on and fought the Chicago police in the streets, the daily political machine. The cops beat the daylights out of them. There's a fascinating description of this when both Pat Buchanan and Norman Mailer were in the same hotel room watching the riots take place around the Democratic National Convention in Grant Park together. Then Mailer comes from the New York City left. Buchanan comes from the Southern right. And so it's fascinating, these two guys, but they understood it at a deep level, what was taking place. Hunter Thompson describes it well, too. And really, it was what they didn't realize was that rioting behavior was not going to redound to their political benefit. It would instead lead to more and more of middle America being less and less sympathetic. The best example of this is you have a guy like George Corley Wallace, who had a very mixed political history. He was a populist, then he was a racist, then he went back to being a populist. But between 1964 and 1968, he went from being a guy who was reviled in the working class Catholic North in 1964 to getting about 25% of the vote of working class white men in the urban North and for president of the United States by 1968. And so that's a history that Trump is familiar with because he grew up with it. But it's clear many in the press have no familiarity with it, no understanding of it, no recognition of it. They really believe that gaslighting these Portland riots in Seattle, Chaz and Chop, was going to turn out well. It's not likely to if history is any preview, and past usually is prologue, as Shakespeare stated. So I think that so that's sort of it. For people who want to understand we went from 1964, peak of democratic liberalism in the United States, to about a quarter century of conservative Republican rule, in my view, almost entirely built on what happened between 1964 and 1968, where the left went off the rails and joined radicalism, Marxism, violence, a cultural revolution that was very much an upper middle class revolution. And they didn't understand that working class people same working class people who opposed the Vietnam War end up becoming supporters of Nixon, who's still pushing the Vietnam War because of their hostility to anti-war protesters who were spitting on their kids when they came home. So the anti-Americanism, the violence, the chaos, these are things that ordinary blue-collar people have no interest in. And so this is not the French Revolution of 1848. They think that's what it is, but it ain't. And I suspect it will redound to Trump's benefit, and it will rebound against them. But it's incredible. I mean, I was telling people a couple of years ago that this felt like we were building up to something like the late 60s, but it's extraordinary to witness it. You see these wealthy scions of big corporate executives writing tweet threads that read almost exactly like the Weather Underground description of their own biographies from 1967. So it's incredible that life could come back in almost identical form. But the reaction to it was ultimately movies like Dirty Harry becoming popular in the 1970s, movies like Death Wish becoming popular. That's how people respond. They don't respond with embracing the rioters and the looters and the arsonists. They end up becoming more authoritarian, more pro-cop than they ever were before. And so for all of my fellow civil rights lawyers, we're going to have a very bad jury environment in the near future. I don't think they understand that. They think that everybody's joining with them. I've already witnessed this in Milwaukee a year ago, where the backlash was already present before all of this took place. So I think we're going to witness an incredible political backlash that's coming, and I don't think anybody's anticipating it. Hopefully, it will not overreach. But when you start to, because they've gaslit so much, whenever the U.S. military or U.S. law enforcement does overreach, I don't think many of the public will believe them anymore. And that's what happened in my Milwaukee case. I could have video evidence, and they no longer even believed the video evidence because they are so used to being lied to by the institutional press. And when you have people doing things that even the Mississippi and Alabama governors didn't do in the 60s, saying we're not going to allow federal law enforcement in our town, even when they're just defending federal property. We're going to file lawsuits to try to preclude them from being involved. We're going to prosecute people for defending themselves, whether by a vehicle or by a gun, or simply by brandishing a gun. This is not the left has more institutional power than they had in the 60s. The old liberal establishment had power, but the left did not. The left now really has political power in prosecutorial divisions, particularly, and they're misusing it and abusing it rather badly in ways that I think that they do not because they do not know their history. They are in fact bound to repeat it.
Okay, and interesting, actually, this was not among the subjects that we were thinking we were going to discuss, but it's a good one to deal with now because we didn't talk about it last week because I don't think the news was out. The Missouri couple indicted on the charges of brandishing their weapons in an angry or threatening manner, exhibiting their weapons in an angry or threatening manner. It's since been revealed that apparently the pistol the woman was holding, Patricia McCloskey, was not able to be fired. And it seems that it was disassembled and reassembled to allow it to be able to be used readily as required by that provision. If that turns out to be true, how is that not criminal manipulation of evidence or criminal? What's the word I'm looking for?
It's misconduct, no doubt. And it suggests that they did not have a basis to prosecute her because she did not, in fact, have a lethal weapon under the law, and that they knew that. And rather than recognize that, they restructured it to try to make it look like it was. And then the internal documentation apparently got to somebody. Somebody didn't cover that up very well for them to be able to spot it and identify it. And so unless they're going to allege that she somehow tampered with the weapon in between the time she brandished it and the rest, but that doesn't appear to be what the allegations are in the internal documentation of the police department. So it's all because of this ends justify the means. There's a good movie out recently called Mr. Jones, which details how William Durante covered up for Stalin's massive famine and starvation of large parts of his population in the 1930s, including, in fact, Durante would, in the New York Times, would win a Pulitzer Prize for that fake news reporting. A Gareth Jones, a reporter, actually uncovered it all. He would end up being killed by probably the Soviet Union, but maybe by the Chinese government for something he was unveiling a year or two later in Indochina. But it details the degree to which they were willing to cover up starvation of 10 million people just to serve a political cause. And it's infected the law. When I was in law school, my first illustration of this, so first semester of law school, 1997, University of Wisconsin, and we had a legal writing class. And the legal writing class was intended to teach us how to write like a lawyer. And so our assignment was we were supposed to imagine that we are an associate in a law firm, and the partner has asked us to give an objective definition of whether there's a legal claim for an adult disabled child to claim loss of consortium for an injury to their parent. Now, when in reading the law in Wisconsin was clear that once you reach the age of 18, that basically they limited loss of consortium claims to when the parent no longer had a legal obligation under the law to provide for the child. In fact, the whole history of the law is disturbing. You did dig into it, and they basically only saw children as material pieces of property. They only valued their labor back in the 1900s and late 1800s. But that's where the law came from. And there's good arguments why that should not have been the case from a disabled child who does have a different dynamic, who was dependent under these set of facts. But that wasn't what the law was. The law in Wisconsin was pretty clear, and why it existed was pretty clear. And unless both of those things changed, the law wasn't going to change. So I wrote wrote the memo to the partner and kept getting bad grades. And I was like, okay, what did I miss here? And it turned out that the template that had been written by the legal writing instructor and her teaching assistants for all of the other teachers who were adjuncts teaching it was that, no, you were supposed to basically pretend, lie to yourself, say, hey, I want the law to look a certain way, so I'm going to lie to myself and say that the law really does say you have a claim, when in fact that was objectively false. And so I ended up going around and around in it, but it was my introduction to how legal education was being transformed. So that's why a lot of the judges you see on the bench today, particularly Obama judges, you see them looking at an ends justify the means. An example of that is one of the Portland suits that both Portland suits got assigned to an Obama judge. And in one of them, he granted the ACLU's request to protect, quote, legal observers and members of the press. And he tried to come up with some manageable definition of that, even though everybody knows in Portland that Antifa will pretend to be members of the press in order to perpetuate violence. And his ruling made no sense, because what he basically said is the First Amendment entitles you to to not obey a dispersal order of federal law enforcement, because because you have a right apparently to witness the criminal activity taking place. This has never been held before. I can't say, you know what, I think a robbery is going to happen over at the bank. I want you to allow me to in the bank to trespass on the bank to film the robbery, because that's important news, by golly.
Well, I think Jake Paul might like this precedent for what he did.
Yes, exactly. I'm sure he will. I'm sure he'll be pursuing it. So it's an ends justifies the means logic. Now, the same judge, it's his own courthouse that's being attacked. And I put out a tweet that said, I would have more respect for that judge if he would disband his own Marshal Protection Service and walk around that courthouse late at night. Of course, he's never going to do that. These judges who are authoritarian in their own courtroom with their use of U.S. Marshals. I've seen federal judges use U.S. Marshals to cover up misconduct when they had illicit conversations with jurors in a case of mine. So to see them have a completely different set of rules for the people defending the courthouse outside than they do for their own marshals, based on law that has never existed before, gives us a mindset of these are very much ends justify the means judges. And so the same thing we're seeing within in the violence in the streets and the rioting and the looting, the same thing we're seeing in the gaslighting. Like I was struck. I went and looked at not only what New York Times reported, but what ABC and everyone else was reporting about Portland, because I was getting people respond to me talking about, why wasn't I defending Antifa people? They wouldn't call them Antifa people. They'd say these peaceful protesters are being attacked by law enforcement. Why are you doing something about it? I'm like, that's not what's taking place there. They're systematically engaged in criminal violence on a nightly basis. And you don't take my word for it. Go to a left-leaning source like Michael Tracy, who's filming it. Go to a left-leaning professor in Portland, Brett Weinstein. And they've both been talking about this. They're both to the left. Both. No one's going to confuse either one as a Trump fan. And they're like, no. What's happening here is dangerous, chaotic violence that needs to be suppressed. They don't want to see misuse of power by the law enforcement, of course. But if anything, law enforcement has been incredibly restrained. So the only difference really between now and the late 60s is you could understand a little bit more of the resistance in the late 60s. You had a neoliberal order that had justified war after war after war, and at the time were drafting kids to go to Vietnam. You had a suppression of civil rights of African Americans, economic, political, social opportunities for all the way up until that time frame. Now it almost makes no sense. That's why they have to gaslight to the extreme. That's why they have to make up stories that don't really exist. And almost everybody, ABC covered the whole Portland protest without once showing a single act of violence, as if no violence was occurring. It was just these nice people are out and about, and for some reason are just getting randomly assaulted.
Well, I mean, we saw what happened with the description of CHOP versus, in the beginning on Cuomo CNN, and what actually happened in reality. And people are sort of, I say they're getting wise to it, but you can't deceive people for that long. But I mean, it is amazing. I mean, the media has its power, but I want to bring up one super chat question right here because I think it's a good one, and it actually illustrates something about the law. Wouldn't a gun be enough for the charge as the person that's displayed can't tell if it's lethal or not? So that was my initial reaction as well, because typically there's a lot of crimes that when you commit with a fake or replica, it's the same penalty because nobody knows. This provision specifically says it has to be ready to use for lethal use, basically.
Exactly. So, and I'm for that. I've never supported the treating a fake gun as a real gun. Now, that's part of what happened to Tamir Rice. He was showing a fake gun, but nobody knew it was a fake gun. So I understand that in terms of police response or anyone else's reaction to it. But we want to encourage people to use fake guns. So if they're going to commit a crime, we want them to use fake guns. So we don't want to punish them the same way as someone with a real gun. Someone goes in with a fake gun, yes, they may get away with a crime, but they're far less likely to kill someone because it's a fake gun. Whereas if it's a real gun, you're creating higher risk of something really bad happening. So I've always favored that the law should treat the two as totally separate. Fortunately, the Missouri law does do so.
All right, because it specifically says the gun has to be ready for lethal use, or what is it? Readily able for lethal use, which explains why they did what they did. And I was thinking, like, maybe there's a second side to the story. Possibly the McCloskeys disabled it after the event to raise this argument. We'll find out. It seems like the excuse for which it was disabled to be used as a prop in a trial will be able to be tested and proven by evidence. But the internal memo that was leaked to NBC doesn't seem to leave much room for doubt. No. It says it was not able to be fired. It was reassembled, and the charging documents say that it was readily, usable for the crime as required by the drafting of the law. Is this going to be enough to justify a claim for malicious prosecution?
Potentially, because that's misconduct by presumably investigative agents, or at least by the prosecutor's office, in a way that's separate and distinct from just bringing a prosecution without probable cause. So it's manufacturing evidence, and that's the kind of thing you can sue for. So the deliberate manufacturing of evidence is considered part of the investigative stage of the case, not a prosecutorial legal discretionary decision, and consequently the law treats that differently, and they have to show qualified immunity, for which they won't have, because there's never been immunity for manufacturing evidence. So it does open up the prosecutor's office to a malicious prosecution charge. And I think ultimately the case will either apparently the attorney general is going to intervene in the case, move to dismiss it, to override the state attorneys, the local circuit counsel, local circuit prosecutor for St. Louis, Kim Gardner, and the governor's promised he'll pardon if he needs to. And I think they should bring a civil rights claim, because I think the statute is, for the reasons we discussed on the last episode, unconstitutionally void for vagueness. and a Second Amendment violation because of the language that it uses effectively precludes a self-defense. And for the people that are asking, because we're now seeing more and more of these car cases, a car is considered a dangerous weapon. So the way the self-defense law applies, now there's an argument that if you're going really slow, then it's not a dangerous weapon. So in some cases that would lower the standard. So it all depends on what the self-defense laws are in your jurisdiction. But if you're caught in a rioting situation with your car, then what you do with it, it depends. Also, if you turn into it deliberately, like what happened in Charlottesville, different dynamic. You're going to be fully prosecuted and won't have a self-defense. If, on the other hand, you just get stuck in it accidentally, then you can use the amount of force necessary with that car that you believe is reasonably necessary to protect yourself from serious harm. And that's where the open question will be. In some of these cases, did the person have a reasonable belief? Now, in Austin, apparently he shot back after he was shot at. So that's a straightforward self-defense case. But in some of these other instances, it will be the context. And, the reason why, Bruce Springsteen even has a song. He says, when you're driving through that part of the street, that part of the city where when you see a red light, you don't stop, reflects the common cultural understanding of the dangerousness of certain places and certain circumstances. And that would be the case here, too. They would be able to show, anybody who'd ever seen the 92 LA riots, that the way that started was they just started randomly attacking vehicles in the neighborhood, throwing bricks, attacking people. It's you can see it at the LA riots documentary that's available on YouTube by National Geographic. From about the 54-minute mark to the 1 hour mark is just the horrific violence that took place against people who just got caught on the south central side of town. And what happened, and anybody who has any familiarity with that, their belief very well may be reasonable if they're caught in a like circumstance, given what they've witnessed over the last several weeks. There's always a risk of a prosecution based on the political nature of it. If you can pull back, that's always better. If you can get around, that's better. If you can go slower, that's better. But I understand people like, I don't want to be that one person that gets pulled out and beaten to death.
No, and incidentally, we had mentioned it before, but in Quebec, we had this case of the taxi driver. It was in 2012, had a couple of, three rowdy customers. They get out, don't pay him. There's a bit of an altercation, but then they jump on the car. They start hitting the car, and he, in trying to flee, ends up running over one of them. He was ultimately, charges were pressed. It was assault. It was assault causing bodily harm or something along those lines. He was acquitted 3 years later on all counts because it was, he didn't do it on purpose. He was trying to flee. He felt like he was in danger. He was acquitted, but that's after a trial and 3 years later. So having a defense is different than using it and availing it and going through the entire system for all of the awfulness
that are violating traffic rules by being in the street in the first place can be prosecuted, and they should start prosecuting more of them to discourage and dissuade this behavior. But so far, I've seen almost no prosecutions brought against anyone for taking over streets and attacking vehicles. And that's the other, that's where they're weaponizing the local legal system to where if you're in Portland, you have no defense. Yesterday, Seattle Police Department basically put out a statement to its own citizens saying, by the way, we can't protect you tonight. That's where we're at. It's a disturbing state. And I don't think the media really thinks this is a winner. As soon as they gaslit the whole world on what was happening in Portland, what happened? Everybody started repeating it. Antifa and BLM and other people who are violent protesters saw it as an opportunity. They saw it as a green light to start doing it in Richmond, do it in Austin, do it in Aurora, Colorado, do it in Detroit, do it in places all across the country. As this spreads, they're letting something loose. They're letting the tiger loose in ways they will not be able to control or contain, and it will politically backfire on them in time, I believe.
Actually, and I'll bring this super chat up because it's an interesting one. Going back to the gun, the fake gun versus the real gun, actually, with Barnes thinking that a law should separate between a fake gun and a live gun, what happens when an officer shoots someone with a fake gun?
That's what happened to Tamir Rice. The Tamir Rice, he was flashing a fake gun to people all day. Nobody knew it was a fake gun. The cops pulled up. It looked like he was going to pull what they thought was a real gun. The cop is falling back and shoots him. Now, the way BLM has told that story is a nice little kid was playing with a plastic toy gun in the park, and a cop just came up and shot him. That's not what happened. Like every other story they tell, they lie or exaggerate. But in that instance, that's what the cop's reasonable belief is. So, or your reasonable belief. If you're a person and someone's pointing a gun at you and you have reason to believe it's an actual gun, you can defend yourself accordingly. So I think, and I don't think it should change self-defense law, because that's about the subjective understanding of the individual. But I think it should change the objective facts about what we prosecute that person for that had the gun. If he used a fake gun, we want to basically incentivize people to use fake guns. So we'll say, look, you're going to get half the sentence you would have got with you got with a real gun. Otherwise, we create a perverse situation where we say, look, we're going to prosecute you the same way, so might as well bring a real gun to the parade.
And also the flip side to that argument is that anybody committing a crime with a fake or a real gun should probably recognize that they run the risk of getting shot by the cops or shot for self-defense, and therefore they would have no incentive to go to a real gun. They might just want to think about not committing the crime with a gun.
Right, of course.
It's an interesting rationale. This might bring us into our next subject, actually. The Supreme Court has just ruled against churches being open. How are we supposed to see this as anything else other than a shot at the First Amendment?
It's not a surprise that Roberts went the way he did, given he'd already done it, but there's no good basis for it. I mean, the law had been clear. They'd already dramatically restricted the scope of the First Amendment as applies to religious expression, because my view is any law that burdens religious expression should meet strict scrutiny. That's not what the Supreme Court has said. They have said only if the law discriminates between churches and other people. And I've never thought that should be the standard. But putting that aside, even under the discriminatory standard, clearly the California case met it, and the Nevada case was even worse, because Governor Sisolak here we have in Nevada, he's a disgrace. But he basically said, but of course, one thing I love about Nevada is the casinos run this state. So we will always have some degree of business reasonableness, because if it benefits the casinos, it will benefit us. But what he's created a huge distinction where basically he's not going to interfere with the casinos. He went along with what they said they needed. It's still not working economically, unfortunately, but then he kept the crazy rules for the churches without adjusting them to reflect how he had adjusted the rules for the casinos. And Roberts, I was curious to see whether Roberts would stick to his guns even after being humiliated by Governor Newsom in his decision, because Governor Newsom used it as a green light to do a bunch of other crazy discrimination. And the idea this has anything to do with COVID is really nuts, in my opinion. But Roberts stuck with it. And so Roberts is going to pretend that anything that happens during the COVID era is okay. And I've been telling people about this a lot. Tons of people wanted me to sue lots of people out of the gate. I brought selective suits across the country. Most of them got resolved. A couple went to court and we won. But I told people up front, challenging the COVID orders across the board is going to be hard, because the courts have a long history. So I chose to find the most egregious examples and sued there. I told people when to bring church suits to wait or to bring the right one. So I brought a suit challenging the inability to even have a drive-in church service, because that's laughably bad. Well, of course, all the smart governors and mayors have withdrawn those provisions when I brought suit. So it precluded that suit from going up to the Supreme Court first. The ones that did were challenging the whole basis of what they're doing, and they're right constitutionally. It's just anyone who's studied American legal history knows our courts have never stopped governments from doing things during a crisis, ever. Every bad, horrific decision in the history of the Supreme Court has come during a crisis for the most part. And that's what's happened here. And unfortunately, Roberts is the classic Hampton cocktail party crowd kind of judge or justice who will not interfere with the executive branch or any other part of government when there's a perceived crisis. Even though he himself has been harshly critical of Korematsu, the reason why Korematsu, if he had been there in 1944, he would have made the exact same decision as the Korematsu court. I'd also been trying to tell all these lawyers to be more political and sensational with how they did their briefing. Unfortunately, a lot of them have decided not to follow that path. You have to. It's your only chance to get someone like Roberts' attention, to say, hey, Roberts, I'm going to accuse you of being the same judge as the Korematsu court, that we have a trilogy of cases that live in infamy. The forced vaccination case of Jacobson, 1905, forced sterilizations in the 1920s, and the Buck case, another totally fraudulent case. And then the Korematsu case, of course, in 1944, all extreme deprivations of constitutional rights and liberties. Almost, they don't, there's a reason why they've only been citing Jacobson. Jacobson led to those two subsequent decisions, but notably those decisions are not being cited by any court because they know how embarrassing and humiliating it is. But the logic in all three is the same. And it's, hey, there's a crisis, so we're going to throw out the Constitution for the time being. And that's what's happening. And it's unfortunate. It's really egregious. And Gorsuch wrote a blistering dissent just to remind everybody of how egregious this was, that we're now favoring Caesar's Palace over Calvary Chapel. So, credit to Gorsuch for doing that. But it's the legal situation we're going to live with as long as COVID is perceived as a serious threat. Even when, in my view, the empirical evidence does not substantiate that at all. As long as the media perceives it that way, that is, in fact, going to be how the courts rule. They will turn it increasingly, several gyms have lost their cases on these shutdown orders. So almost everybody is losing any big, substantial, broad challenge to the shutdown orders because courts are turning a blind eye to it. My cases have succeeded so far, but that's because I was more careful and selective in what we targeted. And then the big takings cases I'm waiting on. So we're going to file them, but we're not rushing into the court system because I know if you get into the court early, they're going to greenlight this. I want to wait for COVID to pass, then get the courts to address this. And if we can get them to address it outside of the crisis context, they may make very important rulings that will stop this from happening in the future. But right now, that's all we can frankly hope for because the courts are shutting their doors to anybody contesting this abuse of power because scary, scary pandemic must throw out Constitution, even though we had like 4 pandemics or the equivalent thereof at the time the Constitution was passed. So it's ludicrous from a legal history perspective and in my view from a constitutional perspective, but the courts are closed for the time being until people get back to a rational state of mind as to this pandemic.
And so ultimately Gorsuch was of the dissenting for basically saying there's no rationale to applying a different standard to churches who can only seat a maximum of 50 regardless of their size, regardless of all the other accommodations, whereas theaters can have more than 50, casinos can be open, et cetera, et cetera. That's the bottom
exactly. I mean, you could have a small casino table or a small casino room that is smaller. There are plenty of small casinos here in Las Vegas. And I would say probably there are plenty of churches that are bigger than them. And so the point was for square footage, it would be easy for these churches to accommodate more people than the rules allow and still be fewer than what the casinos are already allowed and just using the same social distancing and ventilation and so forth and masks, etc. But that was not allowed. It was just clearly an arbitrary rule, and it was indisputably discriminatory. Notably, in this case, they didn't write anything for the majority. I think they just said 5-4. They turned it down, the injunction request. Gorsuch went out of his way to write a second dissent, if you will, because he dissented from the first case, and he just made clear how ludicrous this was. And it will increase pressure on Roberts, but my guess is Roberts will do nothing about this until it comes back around outside of the pandemic context. And Roberts probably won't do anything about it if Trump loses. If Trump wins, then something will happen with it. But otherwise, I think, unfortunately, I don't think anything else is going to come of it. It's clearly an absurd decision in my view. But it's in times of crisis is when the courts ignore the Constitution. And unfortunately, that's been proven once again.
Well, it's very interesting. I mean, incidentally, funny anecdote. When I said I had a bit of a long week, our kids now have a bit of a cold, and I've got a cold as well. And the second anybody has a cold, you can't, in today's day and age, it's immediate freak out.
Yes.
And you have to live in that context. And it leads to the discussion, they're mandating the face masks across the country. And in Miami, is it Miami or Florida at large where they're contemplating, or have they done it yet, mandating face masks in residences, in private?
I think it's both Miami and Palm Beach. I think there's a foreign country too that is mandating it indoors for the whole country or contemplating it. I mean, and the thing here is there is scientific evidence that masks might work, but that's it. In fact, I was going through and preparing for the suit we're filing this week against Trader Joe's for discriminating on disability grounds, reading what the state of California had actually said. And what's fascinating is all their public health officials don't claim there's any scientific evidence to say that the masks are necessary. They say there is limited evidence that masks might be helpful. And it's extraordinary here, especially once you start doing the math. I mean, the math is that for 90% of the people, at least, probably 95, 96% of the people, they know do not have COVID. which means for them, there's no benefit to wearing the mask in terms of preventing its spread from that person. So it's on the speculative hunch that there's some asymptomatic people that are spreading it and at such a viral level that even if you're 6 feet apart from them and you just pass them briefly, somehow you'll get it. There just isn't evidence to support that. And most of the mask evidence going back to influenza said that mask actually wouldn't reduce the spread of influenza in any meaningful manner. So, but I have tons of inquiries about suing. I'm going to start by bringing the disability claim because there's more and more stores that don't recognize. There was a journalist that didn't recognize it, and he took down his tweet after I questioned him on it. But he thought people were making this up. And I was like, no, there's tons of people for a range of health reasons, some for just mental health, anxiety reasons, for whom masks is a risk. The CDC recognizes this. In fact, even the state of California says those people, quote, should not wear masks. Not only do they say they're exempt, they say they should not wear them. CDC says the same thing because no state health authority wants to be blamed for causing someone's illness to get worse or someone to die because they mandated they wear a mask when they knew it was a health risk for them to do so, more so than COVID spreading to them would be. It's recognized even within those standards that there's limitations on what these masks are. But what I've told people is don't expect anything from the courts. So I'm looking at careful selective challenges in the right context, in the right cases, right places, jurisdictions that have too broad a rule, et cetera, for the same reason as creating selective challenges out of the gate to COVID to get judges on the right side to start to move the needle some, because almost every court in the country is also requiring you wear masks inside.
Yeah, so that's why I think the mask challenge is not really it's not gonna go anywhere fast.
Not any broad mask challenge.
No,
the same judge who's making me wear a mask in the courtroom is going to say, you know what, it's insane to require masks. Unfortunately, not.
No, I think at the very least, maybe just admit of certain exceptions so that people stop freaking out when they see the 1 in 10 or the 1 in 20 not wearing a mask in public and breaking out the pepper spray. There was another incident. I forget where it was. It was in the States. Guys at a dog park outdoors and gets pepper sprayed by someone wearing a mask. I think the bottom line is, most people will concede that they probably do something. The only question is how much to justify the mandatory measures in comparison to the violation to constitutional rights that entails. Yes. And the other thing is, I think you would probably get to the same levels of compliance with or without the law, that you'd still have the same 5% who would refuse with or without the law. And then the question is, what's the purpose of the law, if not on the one hand to stigmatize and to possibly allow for, a second source of revenue for the government to go after these people and say, raise your defense later if you have one.
It becomes very conformist. It becomes very collectivist. It becomes once it's compulsory. I'm generally opposed to almost all compulsory laws of this kind. It's my argument about the draft. Is like I don't believe a draft is constitutional. It's never made sense to me that it could be constitutional. I know there's some people that interpret it vis-a-vis the Second Amendment militia requirement that you could draft people via the militia. So that means you could draft people for a national army. Actually, the whole point of a militia was to never have a national army. But putting that aside, there's a fundamental problem with saying, yes, you have constitutional rights, but I can take all of them away and force you to kill people. That doesn't strike me as inherently constitutional, but it's the same mindset. I've always said, look, people say, well, how would you fight a war? My view is if you can't persuade people to voluntarily fight in a war, then by golly, you shouldn't fight in that war. It becomes a little democratic check on it.
At the very least, maybe it's not for the interest. If the people don't feel the need to fight it, it might be for interests that are not aligned with the interests of those who you're sending off to do it.
Exactly.
And so incidentally, someone here, Pink Sniper 28 says, if they mandate vaccinations for COVID, would you take a case opposing mandatory vaccinations? Oh,
yes, definitely. The question is going to be where and when and how. The same issue is bringing the most compelling case in the most politically favorable venue at the best time. I do not believe mandatory vaccinations are constitutional. The only case that's even tangentially addressed this is the Jacobson case, and all it said was they could condition entrance to a city based on compliance with a vaccination during an agreed and admitted pandemic. Now, that decision was still problematic. The court, frankly, lied about the factual record in that case. Back in the old days, the courts and if you go to English courts to this day, Some English courts, they call them a deemster, will actually record the arguments of both sides before they get to the opinion. If you go to some old U.S. Supreme Court cases, you'll see them. You have to go way down to the bottom to get the actual opinion, because often they'll be recounting both sides. They quit doing that so they could start lying about facts, in my view. So courts no longer had to do an honest, very few decisions will give an honest rendition of both sides' arguments. It will usually ignore certain facts it doesn't like, and it will often not even deal with arguments that are raised in a good faith manner. The Supreme Court is probably not as bad as other courts at doing it, but it just happens all the time now, sadly. They didn't used to be able to get away with that. It used to be part of judicial tradition that they had to, as a matter of ministerial obligation, record both argument side for the purpose of preserving the arguments in the record. But so in that context, the same provisions are going to be interpreted. In other words, if they're not going to allow, or if they are going to allow discrimination against churches, you can guess that they're going to come up with some pretext to force vaccines. Now, I think for the people who want to force vaccines, they need to have it at peak panic. And the problem is they're running out of factual arguments for peak panic. Now, they have the press on their side, and a lot of people are still in peak panic mode. Most people will overestimate their risk from COVID by about 100 times over. If you tell them, okay, let's say you're a kid under 15, which is greater a risk of death, the seasonal flu or COVID, they'll say, oh, COVID by a huge margin, when it's actually the seasonal flu for people in that age group by the data we have available to us currently. So people greatly exaggerate their risk from COVID thanks to the press. Only people that are very elderly and that are have co-deathly diseases, comorbidities is what they call them in the medical literature, are at any real risk from COVID. Everyone else is at a risk, but it's a risk equivalent. I mean, to give an example, Clay Travis has been making this point, and he's a good Tennessee boy, so he's smart. I give him credit right away. But he says, look, if you're college kids, they're greater at risk of dying in a car accident driving to and from campus than they are from COVID, because that's what the current data shows. There's a wide range of groups of people for which lightning is a greater threat to them than COVID is. So the idea, but as long as the press and large portions of the judiciary really follow the press, very influenced by the press, as long as they believe COVID is this great threat, they're going to say, well, by golly, we got to do a vaccination to protect the world. And they'll misuse the Jacobson decision to establish a very perilous precedent, because when the state can come and stick a needle in your arm of whatever drug concoction is in there, what constitutional rights exactly do you have if you don't have the right to bodily integrity? And how is it you could have a right to kill a living organism within you that has the potential of at least the potential of human life, depending on who you are? Some people say it is a human life, others potential, but either way, it's at least potential. And yet you don't have the right to prevent the state from sticking a needle in your arm with like animal byproducts in it and everything else. I mean, people should look at what goes into vaccines. It's not some magical heavenly concoction. Should read the book The River about what happened with AIDS and whether or not AIDS may have been a product of a vaccine trial in the Belgian Congo in 1959. There's been a great effort to suppress information about vaccines. Anybody who questions it gets attacked as being an anti-vaxxer. You can watch the film Vaxxed, which actually gets into this in substantial part. I know a good number of people that are in the quote-unquote anti-vax movement. 90% of them are pro-vaccination in general, were always pro-vaccination, and something happened when their kid got a vaccine. It's because if vaccines weren't a problem, we wouldn't have a vaccine court that pays out tens or hundreds of millions every year for damages caused by vaccines. We wouldn't have a whole special legal system that prevents you from reaching a jury trial or a public trial if, in fact, vaccines are so magically safe. They're just drugs like any other drug, and they're as good and safe as any other drug. Some drugs are good, some drugs not so good. And the idea that we should safeguard and keep the public from public knowledge about them so that we can later force a vaccination upon them is deeply problematic. And so I don't think that's constitutional. I think that should be choice. And it's the same thing as like the draft or anything else. If you can't persuade somebody it's good for them, then the burden is on you, and you've failed it as the state. You should not be allowed to force someone to take something they don't want to take. I have the similar view about medicine in general. There's certain religious groups that oppose certain forms of medication. I think they're entitled to that. So I think that but it's going to be an uphill battle. When that battle comes, I hope if Trump gets reelected, there will be no nationally forced vaccine. if Biden wins, we probably will get a nationally forced vaccine, and we're going to have a heck of a, it'll look more and more like a Tim Pool style civil war that he's been talking about for 4 years.
It's very interesting, actually. And let me see what I was going to say. I can't wear. Robert Gonzalez says I can't wear a mask for legitimate health reasons, but my work refuses to accommodate me. What are some of my options?
To simply advise whoever's in charge of human resources that you're protected under the ADA, Americans with Disabilities Act. 30-year anniversary of that act was just a couple of days ago, and that and you can look up and quote the CDC. You can probably find your local government or state government that if that's where the order is coming from, in part, that will say these people should not wear masks. But the CDC is the most helpful, because it has a lot of language about should not wear masks if you have this condition. In fact, they're broad. CDC says if a mask will cause you to have trouble breathing, period, regardless of any other condition, you should not wear it. I mean, they're protecting their position, because CDC just 3 months ago was recognizing masks don't really help much, and that's the other problem here. The only way masks could really help potentially is if they're a certain kind of mask worn in a very sanitized manner, as to when you put it on, what happens when you take it off, how it's cleaned, how it's used. It needs to be an N95 mask. Once they started doing things like, hey, bandanas and cloth masks are okay, which they did for practical monetary purposes, that told me, okay, this is all about a public health experiment, a Milgram experiment, and getting people to engage in certain forms of social control, because even those studies that suggest masks could help talk about N95 mask worn in a very particular sterilized manner, and that has other social conforming behavior in it, and doesn't create the risk that often happens. Scott Adams will talk about it, not in the mask context, because he's a mask fan, but in other contexts. Years ago, for example, they were trying to figure out why people who got like big SUVs got into more accidents than people who didn't. Because the thought process was an SUV would make you safer because it's bigger and stronger, so you'd be less likely to get hurt in an accident. Turned out not to be the case. The reason is because people felt safer. So there's a common behavior that people will engage in riskier conduct when they think they're safer. So it's one of the risks with masks, is that people will take risks they would not have taken otherwise if they didn't have a mask, in terms of social distancing, in terms of what they touch, in terms of where they go, in terms of indoor settings, in terms of ventilation issues that might be present that they'd be otherwise cognizant of. So that's the other risk factor. But for that gentleman and everyone else, you can apply. And I am going to be bringing ADA suits. So anybody who's discriminated against on ADA grounds, that has a health condition and cannot wear it. I'm starting it with the Trader Joe's case. I'm hoping that gets enough public attention that everybody starts complying with the rules. But for those that don't, we will be continuing. We'll probably file 4 or 5 more ADA suits across the country. So they cannot discriminate against you because of your health condition. And the CDC language is clear on that. And often and other clients I've had, they've educated their employer or they've educated the merchant provider, and they've backed off. Like the client I'm taking the Trader Joe's case, she's going to carry the lawsuit around with her. She's like, okay, what can I carry around with me so I can explain this to people? She has a severe medical condition that would make masks very dangerous for her to wear. And I said, well, you know what? Just carry the lawsuit around, because that will probably get their attention, because I'll have all the facts and all the legal recitations and all the evidentiary basis for it included within the lawsuit. And that way she can show it to them. And my guess is your typical store manager is not going to say, oh, screw you, I'm still throwing you out. And the few that are dumb enough to do so will face suit themselves. So that's the goal.
All right, and apparently I can't find the super chat anymore, but American Airlines apparently was not recognizing medical exemptions for wearing a mask.
So, and that person can sue, and they're now. It's a little trickier with airlines. Airlines have a little bit broader basis of discriminatory components they can do. But some of those cases I'm going to be looking at too. Just there's no I mean, I've been on a bunch of these airplanes, and there's a fair number of people who take their mask off for a large portion. And all the airplanes I've been on, nobody's done anything about it. And I think she was even like first class almost. But in particular, I think masks are not helpful on airplanes for a range of reasons, because I think people engage in riskier conduct. But putting that aside, unless there's been a specific exemption for airlines carved out, the same rules should apply. Now, there are some places where different state and federal authorities are carving out all kinds of exceptions, but I would be very surprised to see that, because CDC has been very cognizant that they could cause more deaths by forcing people who have health problems related to masks than COVID could ever do to them for not wearing a mask. So it's likely American Airlines broke the law.
All right, and this is a timely chat from Joshua Cornelius. Josh, nice to see you again. I have a mental condition that makes wearing a mask intolerable. It's called an affinity for liberty and awareness of reality. So whether there's two things. I noticed some people saying if you can smell a fart through the mask, then the mask is doing nothing. Someone else said in a comment, do you cover your mouth when you sneeze? And these are mixing sort of two different issues, because symptomatic people, I imagine, first of all, I think we can all imagine that putting a barrier over your mouth does something. But when you're sneezing or coughing, you're symptomatic, and that's a separate issue. The idea of mandating them for everybody who's not symptomatic because of the potential for asymptomatic spread is another issue. And then the question is, though, even if you believe it, and to the extent that you're swayed by those arguments, the next logical step is mandatory masks in private residences. That's the next logical step, because the majority of the communication or the communicability of the disease far more in your house or in homes than in the shopping center that's only at 25% capacity now anyhow. So if you're convinced by the argument, and I think the logic is there, and I've read studies that say if 95% of people wear masks, transmission will be reduced by 30%. If you're convinced by the science, the next step is masks mandatory in your house. How do people feel about that?
And not only that, if you believe in the studies, you should be requiring all N95 respirator masks, no cloth mask allowed, no bandana mask allowed, nothing but make everybody do an N95 mask. That the N95 mask has to be worn in a particular manner. You're supposed to be taking it on and off in certain times. You're supposed to be cleaning it in certain ways. You're not supposed to touch your face or other things that become more common when you're wearing a mask. And so it was a giveaway to me that they weren't real believers in the masks when they were allowing things that the study said, well, the cloth masks don't really work and bandanas definitely wouldn't work and so forth. It told me, okay, this is more about conformity at this point than science. Now, some people think that that it's good because a part of the belief is if everybody wears masks, everybody will feel the world is safer and the economy and life will return. My view has been the opposite all the way through on this. I've had arguments with Will Chamberlain and others who've been of that mindset, which is, hey, look, a lockdown is good because then people will feel safer and everybody's going to be in panic mode anyway, and maybe the lockdown could solve the panic. In my experience, whenever you do something unusual for a culture, in Asia, wearing masks is not unusual, but here it is. You increase the panic level, you don't decrease it. And there's no better evidence of that than what we're witnessing. People screaming at people for not wearing masks, yelling at people, abusing people verbally, throwing them out of restaurants, stores, establishments, airplanes, etc., threatening their job, all for something that I don't think any of them could uphold an hour of cross-examination from me on even just the scientific basis for the mask in the first place. So that's where I think that it's deeply problematic. All we're doing is all of this keeps increasing the panic level. And I think we have to do things that decrease the panic level. And if you look at the country that has had the least impact economically is Sweden. Sweden has had basically the same profile as most countries that have experienced it. They did screw up the nursing home just like we did, or at least the northern states did. But if you factor out the nursing homes, they're not doing any mandatory masks. They're not doing it in any of the Nordic countries, not Norway or Denmark either. And they're seeing a more normal, regular return to normalcy. Without any deleterious health consequences that are evident, or at least by comparison to us. So that's where I think we should back off the mandatory masks. But this is what happened in 1918. Masks started getting mandated in certain settings. A cop shot somebody in Oregon over this back in 1918. So we should have learned our lesson that this tends to be counterproductive. But we're pushing every panic button instead. And people are getting crazier and crazier about it and louder about it. And I think it's going to backfire more than produce. I would say this for the people who like forced vaccinations or believe in mass vaccinations on a broader scale, like Bill Gates does. I don't think he realizes it, but he's creating the opposite of what he intended. He's not creating more public support. People who are questioning vaccinations were very small. You had Robert Kennedy Jr., some big names, but very few. That number, in my view, is probably up tenfold. Because of this, because people become skeptical when you start behaving the way that our state and governments are behaving. And so I wish they would second guess it. I have a cloth mask, a little American flag mask. that wear for courts and whatnot. Personally, it doesn't bother me. And if it makes someone else feel safer and better, that's fine by me. I understand people who are like, I'm not going to start going down that path because where does it stop? I will bring a mask suit, a challenging mask at some point. It's just bringing it at a point where I at least have a 1 in a 50 chance of winning. Whereas right now it's like 1 in 10,000.
Yeah, no, and I think the bottom line is just to reduce the levels of obsession. And it is interesting. I wear the mask as well. I begrudgingly wear it just because, I mean, I think for asymptomatic people who are keeping distance anyhow, it is what it is. It's the law, and I do it. But it doesn't make people more comfortable. It makes them more fearful on the one hand. And then the flip side is you end up getting people. It's true. I don't know that I see people closer than they would otherwise be without a mask, but it certainly does create that psychological impression that you have this barrier. You can get closer. But I don't know. I mean, I don't know what the studies are on any of that.
Well, and the whole big giveaway of all this is we still just don't know. When I've argued with people about the mask, and I can show them 50 studies that say masks didn't work and influenza, et cetera. They can show me 50 masks, many of which are studies that say, hey, it can work or it does work. And it's all because we have no idea about COVID. Well, we very limited information. We think it spreads by droplets. It might spread by aerosol. It might spread in other ways. We're mostly guessing. We can compare it to influenza, and that's what I do. And I say, based on that, there's a lot of reason to be skeptical of the efficacy of masks. But putting all that aside, we're in this huge range of uncertainty. So the question becomes, how much does a public policy produce better public reaction and more safety versus induce more panic? And I think masks are creating more rebellion and panic than they are public safety.
That's the issue. More rebellion on the one hand, more panic on the other, more, I would say, I think we'll find out sooner than later, more stress in terms of the immune system in general, more social division. Whereas I think you'd get the exact same level of participation if it were not legally required, but only, social pressure, for lack of a better word.
Well, and you have people that are like, there's people, I guess it's true. I mean, at least what they're saying on Twitter, that have not left their apartments in 133 days. It's like, well, hold on a second. It's like, well, what we have people completely panicking. I know when I was in New York City, that city felt like one big fog of fear was just weighing on the city. It was the worst environment I've ever been around in New York. And New York's always been a brash city and not bashful. But it was disturbing. It was not like New York. It was no longer a proud city. It was a scared city. And I was like, this is not a healthy mindset or mentality to have. And clearly the approach of lockdowns and masks and the rest has not induced a confidence in the public. It's induced a fear, a paranoia in the public. That's like out of some kind of horror movie where they're waiting for the ghost to come around the corner.
I mean, I agree. I think we would have had the same level of cooperation without the excess levels of division and I say panic inducing. And the funny thing is, I blame. This is all anecdotal, which makes it totally irrelevant. But our kid goes back to daycare within a week, gets a cold, and I do wonder if 4 months without intermingling with other people, I do wonder what it does to your immune system. It makes you weaker or more susceptible of other stuff.
That was the argument of the Bakersfield doctors. I mean, that was their argument. There was argument. The reason why we engage in society is, and that's clearly the case of like Jared Diamond's Guns, Germs, and Steel. His argument is that the domestication of tigers and wolves into cats and dogs allowed Westerners to develop immunities to a much wider range of disease, and that's why they were able to conquer all of the Americas, because Native Americans had not experienced that, and 95% of them didn't die from cavalry's coming and shooting them all. There wasn't that kind of genocide. It was because they could not survive the diseases that we carried from the West. And so I in my own view is that doing things that are so psychologically harmful to people is generally not going to be productive over time. That I have to be convinced that there's overwhelming evidence to support these kind of restrictions, because I come from a presumption that those restrictions will be counterproductive. We know at least how they will cause harm. We don't know what benefit they procure. And when you're in this environment, like legally, we're supposed to weigh that out, but you have all these courts saying, oh, geez, we can't weigh it out. We have to defer to the executive branch. They never defer to the executive branch when it's Trump, but somehow all these state governors, they're happily deferring to. And these state governors are bigger wusses than any bunch of people in a group, but we'll see. But yeah, it's a level of insanity that it just keeps topping it off. And then you have all of this in the context of more evidence coming out about how crazy Spygate became. Like, it was its own form of paranoia and hysteria, that they basically were some kid working at a think tank, spent time drinking with beer with some of his buddies, went and told the story to Steele, and Steele used that as his secret super duper Russian inside Kremlin source. And we got massive surveillance, massive criminal investigations, massive prosecutions out of all of this, and it completely contaminated and cast a cloud over Trump for 4 years. It's insane. I mean, the evidence that's coming out, for people who want to understand it, I'd been telling people 4 years ago that when it all comes out, we're going to find that Chris Steele is just another Our Man in Havana, based on the book by Graham Greene. Great movie from, I think, 1958, 59. They filmed it right as Castro was coming in. Or Taylor of Panama, written by John Le Carre, also made into a movie with Pierce Brosnan in, I believe, the mid-2000s. And what people forget about both those authors, Graham Greene, great writer, John Le Carre, great writer, both of them were spies earlier on in their life. John Le Carre actually started as a spy before he became a writer. He was inspired to write because of his experience as a spy. The Spy Who, I think it's called The Spy Who Came In From the Cold. It's the first one, I believe. Great. I mean, Russia House is one of my all-time favorite. People want to understand my theory of government. It's basically the movie Russia House. So you have to watch it to get what I mean by that. But between Dancer Upstairs and Russia House are the two movies that define my perspective on politics in the world. But John Le Carre brilliantly in Taylor of Panama, the whole thing's faked. The guy finds a tailor to come up with crazy concocted stories so he, the spy, can get famous, powerful, and rich. In Our Man in Havana, he needs the cash. So he's a drunk guy, a drunk buddy of his, inspires him to just start making up crazy stories that everybody ends up completely believing and almost leads to war. And the point, and the reason why Graham Greene and John Le Carre wrote those is they said their experience was that spies more than half the time just made stuff up to satisfy their bosses. They'd find some source, string some combination of rumors and innuendo together that sound like something they would want to believe is true, and that's how they would get promoted. That's how they would get their cash. That's how they would get personal benefit. And Steele had that written all over him from the get-go. So I told him from the get-go that there not only was there no Russian collusion, you're going to find there was no Russian government agents even connected to any of this, that they're not going to find any Russians that are connected to this. This was solely some guy's drunk made-up story, like Taylor of Panama and Our Man in Havana. And now it came out this week that is in fact what was the case. Chris Steele had no Russian sources at all. His source was a guy who had some old buddies who were Russian, who was a young kid working at a U.S. think tank. The guy wasn't even Russian. I mean, that's where they were coming up. That's why they've been trying to hide and suppress the underlying evidence. You see why they had to get Flynn to plea. Flynn would have uncovered all of this if he had real lawyers back in 2017. That they were going to be in a disastrous situation had he demanded because he understands how the intelligence agencies work. So he could have uncloaked all of it, top to bottom, left to right. That's why railroading him was so critical to their ability to get away with it as long as they did.
Well, it's an interesting thing. Now, a lot of people are hypothesizing as to why Sullivan is dragging this out, the vendetta, and there's a lot of jokes that Sullivan is taking his orders from Obama. Is the idea that first of all, is the gag order still in effect on Flynn?
There was no gag order ever issued on Flynn, to my knowledge.
Okay, so I might be getting mixed up between. So the idea is that this is what Flynn would have been discovered, or what would have been revealed had the pressure not been what it was to plead and to make this go away a few years ago.
Oh, exactly. I mean, he could have unearthed all of it. So if you're the government, you've got to coerce him more than anyone else. Stone's people weren't going to be able to put it together. Manafort's people weren't going to be able to put it together. But Flynn is a long history in intelligence, so he would have been able to put it together. And so the key was we've got to get Flynn to plea early so he's out of the game, so he's not demanding putting all of these pieces together. Because if he would have pieced together, this was one big fat fraud from beginning to end. Not only the case against him, but the broader case against the president. This was a coup attempt, but using the worst cinematic versions of spydom. And you see why Comey and the rest were paranoid about suppressing this. I remember when they first talked about releasing the source, the New York Times and all these people were saying, "Oh my goodness, you're going to force the disclosure of this very important source." President Trump's trying to get people killed now for being important informants against Putin. Well, I knew from the get-go there was no way that it was a high-level source. This was all nonsense. And of course, what they were really trying to disclose, and this is what the government always does. The government always says law enforcement secrets, our national security secrets require us to keep secret our confidential informant. I had a case like this that was almost right out of the show The Wire, where in season 4 of The Wire, another great show that explains how law enforcement really works in America, and good for explaining the drug trade and major urban politics. Basically showed that the two main cops decide they figure out, we can put down a wire that they didn't have legal authority to, and we'll just attribute it all to our confidential informant. And maybe a year or two after that aired, I had a case where I was going through the supposed informant's disclosures to my client, who'd been illegally brought back from Panama. And he's like, okay, I was like, who is the person here? Because I was trying to recreate who is the one individual this could be. And he's like, there's no one person here. He's like, that was a conversation I had with my daughter. That was a conversation. I was like, oh, these are all illegal wiretaps, and they're laundering it through a bogus informant, just like The Wire. I got to live a TV series in my law practice. But it's amazing how often that happens, particularly in the spy world. 9/10 of what the spy world produces is complete crap. They're not geniuses. They're not great insight people. Just watch towards the end of The Spy Who Came In From the Cold, and John Le Carre, and this was a movie back in the 1950s, does the greatest indictment of the spy world you'll ever hear, about how they're just mediocre people who play with other people's lives and make lies up in the in-between. And that's what this always was. The press must have known it at some level, so they hid it. Everyone else hid it, because if you had a real high inside source, you would brag about that high inside source. If you were the press, you're like, when the truth comes out, a big important person. No, they knew from the get-go this was a kid in the U.S. who worked at the Brookings Institution, who had some drinks and some beers and spread crazy rumors, and somehow it became a FISA warrant in the United States. That tells you what a joke our CIA director was, our national intelligence operators were, leading people in NSA were, leading people at the Pentagon were, and the entire 7th floor of the FBI. One big, huge joke. And these are people that were deciding who could go not only be investigated in a mass scale, but who could be imprisoned on a whim. That's why Spygate's much bigger than Trump. It's about the corruption of our intelligence agencies and the corruption of our national security apparatus and the corruption of high-ranking law enforcement in the United States. And Sullivan's just trying to play the game. The problem is this: once Flynn is fully publicly vindicated, it puts the camera and the light right back on Obama and other people, and Sullivan's trying to protect that old Washington crowd that he has been part of for a quarter of a century.
Okay, amazing. And now someone had asked in the comment section of my last video on the subject, what's the timeline now again for the Court of Appeal in theory to render a decision?
They should decide by whether they're going to take it or not by next Friday. I'm sorry, this coming Friday. So they should decide by then whether it's yay or nay. I hope they say nay. Now, if they say yay, then there could be another round of briefing, and there could even be oral argument. There are 7 of the 11 judges. Some people were thinking that it's a majority Republican panel, but that includes senior judges. Senior judges do not participate on in the en banc panel. The en banc panel is just the 11 active judges, and 7 of those are Clinton or Obama appointees. So there is a risk they take it when normally it would make no sense for them to take it.
All right, I'm just going to bring this one up before we move on to the next subject. But Guy Ross, Robert, what social or other ramifications have you endured for voicing unpopular contrarian positions in LA? Well, I think Robert's mentioned them a bunch in the past with Nader, Wesley Snipes. Good question, but we'll do it maybe on a when there's a slow week in the news.
Sure.
Okay, because I hear some kids screaming, and I'm not sure how much longer we're going to have.
I got you.
Here's the question. Let's move into Breonna Taylor.
Yes.
I know
you probably know the plaintiff side of the case. Well, I know part of the plaintiff side, and I know the defense side a little bit better than I do the plaintiff side to some degree. But I think you've read the plaintiff suit, so you can probably give that description.
Well, I read the suit. I've shot the content for the video. I just haven't. I didn't have enough time in the day to do this. But the question that I have, that a lot of people have, is the first question: whether or not it was a no-knock warrant. I'm saying in the video that there's a number of disputed facts, whether it was no-knock versus knock and enter, or knock and identify. How are no-knock warrants constitutional in the first place? How's the justification for that come to be?
Sure. So people could also, Brandon Tatum did a good video on this, on no-knock warrants. So the background for, I've been a critic of no-knock warrants, but there is a reason for them. And in some cases, no-knock warrants are safer. Ironically, in the Breonna Taylor case, it may be the case that they would have been better off with a no-knock warrant. So the grounds so normally the way a warrant happens is you have a authority from a judge to search a particular set of premises for a particular set of objects. So sometimes people think a search warrant allows you to search the whole house. It does not. It allows you to search the parts of the property that are identified in the warrant. Also, some people think you can search for anything. That too is not true. You can only search for the things that have been identified with particularity in it. In the old English colonial days, we had general warrants where they would just walk into your house and search for anything and everything. That was so hated by the colonists that was part of the reason why the Fourth Amendment required what it requires. So the first part is the search warrant has to identify the premises that are being searched, has to identify in the exact scope what is going to be searched within those premises. So, for example, if you get electronic equipment, there's specific limitations on how you can search that, etc. You can't always search in every part of the house. Sometimes only certain parts of the house, depends on the warrant. And then the other provision is that the protocols for executing a warrant is generally a knock and announce. Hey, we're police, come to the door. Police, come to the door. Usually they used to call it, I've had, some old defendants used to call it the 3 knock, the boom, 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 is what you would hear. And they would say, police, 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 come to the door. Now, a no-knock warrant was used for 2 different reasons, sometimes for police reasons, sometimes for safety reasons. For police reasons, the fear was that when you came and knocked, the defendant would get rid of the exculpatory evidence. Or it would get the incriminatory evidence, rather. So they would get rid of any, like they dump the drugs down the toilet, they burn whatever's there, they throw something out the window, things like that. The second reason for a no-knock warrant would be safety, which is the idea is if we knock, they're going to come out guns a-blazing. Whereas if we go in before they can do anything, we can have the scene secure before they can shoot back. And so those are the reasons for a no-knock warrant. Now, what's happened over time is courts have got loose. I have a strong hunch that very few courts deny any warrants anymore. So I brought what should happen before a warrant ever happens. And it all depends now more and more on the police departments rather than courts. Some police departments have strict protocols. So they require you to do, give me a lot of evidentiary basis. Why should we do a warrant rather than something else? They see that as a dangerous escalation in many contexts. The IRS is not even supposed to have a lot of search warrant authority. They misuse it and abuse it all the time. And then up next, scope out the property. Make sure the property is what you think it is. Make sure you know who's there. Make sure you know, are there going to be kids on the property? Are there going to be elderly people on the property? What's their time procedures? When do they go to work? When do they typically go to sleep? When is their activity there? Know everything about this. Scope out the scene multiple days in advance to get detailed information, detailed understanding of what's taking place. And then you ask, the police officer files an affidavit of probable cause, gives it to the judge. The judge is supposed to review it thoroughly and say, hold on a second, I see a problem here. They're clearly with the Breonna Taylor warrant, very generic. Now, the arguments for Breonna Taylor are the only grounds they clearly had not scoped out the property much in detail. They did not even know that her boyfriend was present. Did not even know she had a boyfriend, apparently. Believed that their only evidence was that packages were going there in her ex-boyfriend's name and that she had visited her ex-boyfriend who was a drug dealer. Very limited evidence to do a search warrant. Even more limited, their only grounds for no-knock was the generic, oh, by the way, whenever we've raided a drug house before, they've often dumped evidence and shot back. But they didn't even claim this was a drug house. So that was not sufficient grounds to get a no-knock. Now, it may not matter in that context because it appears they did not, they claim they did not do a no-knock. They just went ahead. They had the authority, but didn't actually use it.
They claim they knocked and announced and then busted it down, but Lord knows what period of time we're talking. And is it the 3 knocks where bang, 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 it's the cops open up and then all hell breaks loose? And speaking of the house, apparently it's it's a housing unit that doesn't necessarily look like it would be one for drugs. And there's apparently a 5-year-old kid and a pregnant woman next door.
Those are also things they're supposed to scout out. So they're supposed to scout out what are the exit points, what are our risk rate points, where are we coming in from, who's at the house, or especially apartment buildings are riskier. Normally, search warrants are done at a house. Who's next door? Who's to either side? Same with if you do a commercial residence, commercial property. Who's on different locations? Clearly, they had not scouted this out in great detail. She was the tail end of. She was not the main primary target. They executed warrants on the main primary targets, arrested them, the actual drug dealers. She was sort of, maybe we'll pick up some extra evidence. And the best evidence, some of the best argument for her is there's dispute about whether they knocked. There's dispute about whether they announced. They shot 25 times into the property. One person has a history of, as I've said in our prior ones, if this was problematic, you'll find a cop with a bad history, and there is a cop with a bad history again involved. And that's why these things happen. It's because the police departments and the prosecutors don't clear out their bad cops. It's 9 times out of 10 what the story is. And so that's all of her argument. Now, I would say when I see the Tampa Bay Rays saying arrest everybody now as their baseball announcement for whatever it is on opening day in Breonna Taylor, and of course LeBron he's got to give his 2 cents. It isn't as clean a case from a prosecutorial perspective as some of the press and BLM has made it out to be. She was, in fact, connected to a major drug dealer in Louisville, had been her ex-boyfriend. She had repeatedly gone to his house where he dealt drugs out of within the same week. And she did allow him to send packages to her house. So it wasn't like the cops had no basis at all to think there was a reason to search. And if the key factor here is going to be a who shot first case.
Yeah, so, well, but then I was thinking that, and I'm saying that's going to be one of the other disputed facts. The civil suit, and I mentioned it in the video, doesn't even mention that her boyfriend shot. It mentions that he was a licensed gun holder. I said it's sort of a not a fact that you should omit because it's going to come out sooner than later if it's true, and it's not going to do any good to hide it. But even then, assuming that the boyfriend did fire first, assuming that he had a reasonable motive in his own spirit, is the rational response to fire back 25 plus shots into a house where you don't even know what on earth you're firing at, or I don't know what police protocol is. Are you supposed to recoil and then reassess?
Well, this is going to be a lot like I think they portrayed it in Trial by Media on the Netflix series. One of their cases is the famous New York case, the immigrant who was shot 41 times on his doorsteps. And that the bunch of officers were tried for that. They got the case moved for venue purposes, and they all got acquitted. They also portrayed the Rodney King case. And so if you want to understand, how do you, that was the argument of the Rodney King case. It was, okay, you thought he was on drugs and wasn't going down for some reason, so you're trying to use force. But at what point was that reasonable force when you're continuing to beat the daylights out of him? What's fascinating about both those cases is Rodney King case in the state trial, they all got acquitted. In the state case in New York of that guy, he got shot 41 times. He didn't even have a gun. No history at all. All of them got acquitted. Now I can tell how that happens. They find a jury. A lot of juries are sympathetic to cops, and they take it through the cop's eyes. So the key is, will they see the case through the cop's eyes, or will they see the case through the defendant's eyes? To you or I, that number, just like that number of blows of Rodney King, that number of shots in this case doesn't make sense. It isn't consistent with reasonable force. When a woman who apparently committed no crime is now dead because of it. And when there was dangerousness of those guns being used with neighbors and the rest. But to the juror perspective, if they walk through the cop's eyes, it will be the cop is terrified. One of them's already been shot and has gone down. They think they're about to be and I can tell you the story they'll tell the jury. They'll tell the story. They'll tell all the horror stories, of some cop who goes in, who doesn't pull his gun right away. And everybody, a bunch of cops end up shot or dead. Of how drug houses typically have guys with AK-47s and automatics, and they're just firing away. And if you don't fire fast, you're dead, or your brother next to you is dead. That's the storyline they're going to tell. And the key here, I mean, one of the best things for Breonna Taylor is that her boyfriend is calling police. Her boyfriend is calling cops, calling his mother, and calling other people, saying, I don't know what's happening, that somebody's coming in and trying to raid the house, raid the apartment building, and so forth, and that he was firing in self-defense. And a big key is clearly going to be who shot first. I think he probably did shoot first, just because it'd be unusual for cops to come in and shoot first. But you have one cop involved. who again has a long history of excessive force, according to the complaints against him, at least. So that's where like I understand the Breonna Taylor side of the equation. I think that that they have overstated aspects of their. I think some people have exaggerated aspects of her case. That it wasn't like the idea that this was just a summary execution. That isn't what happened here.
No, it's
these are cops who panicked and maybe and made a bunch of mistakes in the lead up because they didn't know he was there. They just a bunch of errors that they made in executing the warrant in the first place. But they clearly could have pulled back, clearly could have made sure they were announced further. There's a bunch of steps that they have training to do. Now, these are Louisville cops, so they're not federal law enforcement officers. They don't necessarily have the best training. We'll find out about that. But I think one of the ironies is if they'd done no knock, they probably ambush them with, and nobody maybe gets shot. Don't know, but that's why I think the no knock warrant part is more of a red herring in this case. Because the reason why I believe the cop's story that they knocked, and by the way, knock just means knock 3 times. Then you got 3 seconds, and then boom, that door comes down.
Well, it makes sense that they knocked because if in theory he had time to call the cops, so it's not we're not
exactly. Given his reaction time, it only makes sense that they did knock. He may not have heard he heard something, but clearly they must have knocked. And the irony is, if they hadn't, they may have ambushed him quickly enough to where none of this happens. So I think the no knock side of I'm not a fan of no knock warrants. I believe it's too risky unless the cops are much better than these cops proved to be, and other cops have proven to be over time. I have a case against an illegal. They did in a small town in California. They went and raided my client's house. Her little girl was there, terrified her. Another kind of just quick entry situation. Were screaming at her, dragged her little girl out, and they had the completely wrong house. Who knows how many times this happens? So they need to be much more careful. What happens? These cops get eager. They think they're onto something, and they rush in. They're like, "Oh, we better get the warrant today." That shouldn't be happening. That suggests a problem within the police department in terms of their supervisory controls over who can request a warrant and how it goes about it. And I hope the lawsuit exposes that. But yeah. I agree with you. They always do this in these cases. They try to hide the bad facts. The fact this whole case is about him shooting first. Now, he was initially charged with attempted murder
of a police officer, which they dismissed the charge in May.
Correct. And that was good public relations by his legal defense team and by other people on his side, because otherwise that case marches forward. The cops were mad that he wasn't getting prosecuted quicker by pushing how bad the cops handled the Breonna Taylor case and the horrific consequence of a young woman's death. That allowed for the police, for the prosecutor to re-examine it and realize it would be insane for me to pursue this case given the disputed facts we have. We have at least one rogue cop that's here, and given the public relations campaign back against me. So I think he was just trying to defend himself, because he wouldn't be making the calls he was making if he really thought those were law enforcement officers at the door. And it's a risk, but people think it's a risk of a no-knock warrant. My thing is, no, this is a risk from any warrant. Because they go in, they do not wait for you to get to the door very often. And I've disputed that with them in the past, in other cases I've had, especially like it's a tax case. It's like, come on, all the secret documents are going to get shredded within the 2 minutes, but that they do this all the time. They bring SWAT teams to tax cases. They got 20 people with machine guns outside.
Well, I read one of the stats was that apparently in the early 80s, they had 1,500 no-knock warrants issued in a year. And by 2010, it was like 45,000.
Yes.
Whether
what happens. They love them. Like I said, there is an argument for them. That argument is that there are times when it's safer for everybody if they have a no-knock warrant. And like if you're busting in a real gang, if you can ambush them before they can get their guns and fire back, that's a safer situation, including for the guys, because usually those guys firing back don't live. So there are but it should be limited. And the problem is, once we open the door, it's like anything else. It's probably the best argument against masks. Once we open the door to one thing, they always open it up to everything else. And judges the other people who this is on, there should be a lot more criticism of that magistrate. Why did the magistrate sign such a thin warrant based on such a thin affidavit? That's on. In other words, here they're saying we're going to raid somebody's house who we have no evidence has committed a crime. We just believe there's evidence of criminal activity present because it's a drop-off place of packages. They weren't even alleging that she knew what was in those packages. They had no reason. She had no criminal history at all. She was a nurse. So I'm mostly on her side on the case, but I'm agitated that BLM has exaggerated some of the facts of the case, and I think put too much of the blame on no-knock warrants when there's a problem with how these warrants are executed. There are not no-knock warrants, period, and it appears this wasn't a no-knock warrant actually in practicality. This is what happens when we encourage cops to just raid houses, but it's also because judges aren't supervised doing their job, and supervisors are not doing their job.
And it's the ultimate point of my video is, defund the police is not a message that most people are going to get behind, but demilitarize the police, because this reads, it reminds me of the scene in Copland with Michael Rappaport. I mean, it's like a bunch of cops, and someone says, only 25 shots were fired by 4 cops, not that many. That is, you're firing into a house, a residence, what is a place where people live, with absolute disregard for what's going on there. You don't even know what you're firing at. And so
exactly, and it's an apartment building. This isn't like a home. So where those bullets go, whether they go through a door or a window and hit somebody else in a neighboring apartment. This was not a very fancy apartment building. It wasn't like totally run down, but it wasn't exactly fancy. That they don't do a lot of these kind of, well, at least I didn't think they did a lot of these kind of search warrants, because it's always problematic to do in an apartment building anyway. Because there's all kinds of things that can go wrong. So I think that there was a lot of problems, and I don't necessarily blame all the cops at the scene. I blame whoever. There's one apparently who shot most of the shots. He shot at least 10 or maybe 15. Like, most of the bullets came from one guy. And it's the one guy who has the long, bad rap sheet of problematic complaints.
And 2 issues which are not going to help the defendants either is that one of the cops was fired, 2 were reassigned, and apparently they had already had in custody the individual who was ultimately at the object of the search warrant to begin with. So
now, in their defense on this one, they were looking for evidence on this one. So they weren't looking. They didn't think he was there. They thought that there were he was stashing drugs there. Now the other problem for them is apparently the post office is denying that they had really done a full investigation with the cooperation of the post office to know what was in those packages. So there's a dispute of fact there, because what was put in the affidavit was, but I think what the affidavit was probably still true. All he said was, we know that the packages for our target come to this woman's address. We know this woman visits him repeatedly and has had a prior relationship with him romantically. And so their assumption was, we believe these packages are drug packages being stashed at her house. So we're raiding her house in the middle, and this was the problem, raiding her house in the middle of the morning, the early morning hours, where it's going to massive panic. When you don't know she's a drug stash house, you think she's coincidentally. I mean, that evidence could very easily show innocent intent of someone who may actually have drugs on them, but have no idea what's in those packages. And by the way, I know people are saying it was just clothes and everything. It is still a little odd that he was using her as that location for anything getting forwarded, and that she was delivering it to him. That's not normal behavior, but there was at least an innocent explanation for her behavior that was sufficient to say this is not a search warrant case. And so I think there is a probable cause problem they have, not as bad as the BLM critics have made it out to be, but definitely not a strong case in a typical case. So I think they're all going to be in trouble. Louisville's going to write a big fat check. But what I hope happens is that the plaintiffs force institutional change, structural change, because this might be a good transition to the Sandmann settlements.
Actually, before we get there, just 2 of the transitional changes, or the structural changes. Apparently, Louisville has now banned no-knock warrants. Yeah, and there was one other issue which I'm going to get to in a second, but I've forgotten now. That was firing one cop and reassigning the others. Yeah. But
to me, the real problem here was supervisors, and the real problem here was I don't put it on street cops. Now, the one cop had a history, so I put the shooting back on the cops. But this was a problem from lack of planning, and from lack of supervision, and from lack of judicial review, because those are the people that have the most knowledge. Your street cops have a certain degree of knowledge, but it's your judge who knows which ones go AWOL, which cases go bad, what their job is supposed to be. And if you have the right supervisory controls, you have people who've reviewed hundreds of warrants. So they know the ones that are good and the ones that are problematic. It's clear that neither of those existed. And my concern is that these cases tend to focus on individual officers, presume racial prejudice in terms of BLM's arguments about it, and they're missing the bigger institutional problems that really need fixing, which is strict supervisory controls with knowledgeable people within the police department that limit the scope of warrants even being requested in the first place, and judges actually doing their job in enforcing the Fourth Amendment. And judges can also, without even striking down the warrant, they could say, hey, look, I want this or this or this. I want this added to it or this. And they could have made this safer, and this never would have happened. This is as much on the judge who signed that warrant as it is on anybody, because she was, or whoever the judge was in the best position to know.
No, totally agree. Now, I just want to read one super chat before we end with Sandmann, because I didn't get to it. It was J-Mail says 2 things. It's my birthday, and this was literally the only thing I've been looking forward to all day. 2, why can't anyone persuade Ray to produce Joe Pientka, other agent who interviewed Flynn?
I mean, any of those people can be produced. So, for whatever reason, the Senate, I think Graham is a showman. Graham doesn't really care about getting to the bottom of this. He's a deep state hack, as he always has been. That's really why he's in charge of that particular committee, in my view. So I have a very low estimation of him. He only grandstanded on this issue because he's up for re-election. So he'll drop this like a hot rock as soon as the election's over. He's not going to. Now, Nunes was sincere. Nunes is the real deal. But he's no longer in chairman of his committee because the Democrats took over the House. So that's why I think that is. But there, any of them can be produced legally. There's no reason why any of them couldn't be produced. Oh, you're on mute, Viva.
Sorry, I don't want anyone hearing when I'm sniffling. So it's
no problem.
Okay, so let's say I was looking for a comment, but I lost it. Let's finish up on Sandmann. I don't want to ask you questions that you're not allowed to answer.
Right.
He settled. There was an article in Fox News, and the journalist said after his this follows the multi-million-dollar settlement with CNN. Now, that was the first I'd ever read of an amount, and I messaged the journalist just to see if he meant it was the settlement of the multi-million-dollar suit, because I had never heard of a multi-million-dollar settlement with CNN. I mean, we all hypothesized. What do you I mean? So I got no response, and the article hadn't been changed. So I don't know. Maybe someone slipped up. What do you think the chances are that it was a multi-million-dollar settlement with Washington Post?
Probably very, very low. Just because the range of those settlements tends to be in the 5 figures, sometimes 6 figures. But it's lucky if you get up to 6 figures in most defamation cases. But I think the main benefit of the suit is going to. I think on the upside of the benefit of the Sandmann settlements is that it will be a public deterrence as people see that there can be consequences to this, and there's at least a perception that it may have been for a substantial amount of money. My own perspective for representing the Covington kids, separate from Nick Sandmann, I don't represent Sandmann, he has other counsel, is my focus has always been different. My focal point was not to get a big private settlement because I thought that we needed to use this to change the law and to change the way people approach the law in terms of getting people to have substantive institutional reform. So a classic, now, like if you were representing Breonna Taylor, you have to do whatever whatever your client wants, which would be her estate, her significant others. So I would understand that context. But I think that if we want, I prefer, and luckily in Covington case, I had a bunch of clients and have a bunch of clients who want to see systematic reform. They don't want to see this happen to other people. They want to see the legal system change in such a way that we can reform it. And that can only happen if we do not have any secret settlements. So my goal is not to have any secret settlements and to have public change, public recognition of wrongdoing, public corrections and apologies, changes in policies and procedures, and the rest, and not looking for a big payday. So I think the Sandmann settlements are good in the sense that they send a message that people should not behave this way. A lot of people have asked me about what I'm doing in my separate cases, and I've taken a different approach because my objective is different. And I believe it's the only way to achieve real change. I think for the Washington Post and CNNs of the world, their insurance policies are huge. So these are just insurance companies writing checks. And generally, the insurance companies control the representation. The Post doesn't control it. CNN, the companies themselves don't control it. The insurance company picks their counsel. The insurance company determines settlement. And so, what happens is they tend not to change much. So they take a PR hit, which I think is valuable. And I'm glad the settlements occurred. But my view is I want to make bigger changes, structural changes that can make a lasting difference over time.
My thinking first, my initial prediction was I predicted in the original assessment I did of the CNN settlement 5 to 20 million, and I'm sort of thinking that might have been way overboard, and maybe 1 to 5 is more reasonable. I tend to think that the settlements might have been good, because if they were bad, I think they would have leaked, and if they were bad, I think we probably would have seen settlements with the other news agencies. I think they have to hurt a little bit if they're not being publicly disclosed.
What a typical insurance company would look at this case as that it would cost them $250,000 to $500,000 to defend it. So they might settle for something in that, up to a certain stage. It can get into the millions, but it generally is on the lower end. So I would be surprised that even a 6-figure amount. Doesn't mean it didn't happen. It just means that knowing what I know about defamation cases and how insurance companies value them, they would see this case as low risk of them losing a big amount financially at trial. They could have been held liable, but the financial amount was not likely to be high because of the circumstances. And so that's why I mentioned that to other people just so that people don't think, oh, you can get rich with defamation lawsuits. No, it's a very rare suit that you ever even get back anything of what you got damaged for. That in Kentucky, the highest libel verdict I know about in a like circumstance was the equivalent of $100,000 in today's dollars, and that was a much worse set of facts than here. So that's where my guess is the insurance company, and it may be the case. So, I think if some people that are in Sandmann's position may have valued different things than necessarily a huge amount of money. But it could have gone. It could have been high too. We'll never know. Sometimes that information leaks, but usually it doesn't. When I've settled cases with real low amounts, you're right. At least I have required that amount get disclosed. So when Alex Jones settled the Pepe case for $13,000, which was a joke low amount, was less than spending a week out there. I required that the settlement terms not be confidential, so I could tell the world we paid them nothing, and they spent $1 million in legal fees, at least in their time, to get $13,000. So it would discourage people from suing in the future. So you're right that typically that information does leak. The only thing here is it's the insurance company that's controlling it. It's not really Washington Post or CNN that's controlling it.
Which is why a lot of people are saying that they might want to pay 10, 20 million to avoid depositions or discoveries, which might very well be true. And we don't know necessarily what the insurance relationship was, if it required the approval of the insured. But
their policy limits were probably 10 mil, might have been higher, but typically those companies, your average media company has $1 million policy. Your big ones have 10 million. Most don't have much more than that because it's very rare for them to get hit with big verdicts. So the big verdicts are extremely rare against the media.
Well, that's why some people were thinking that it wasn't necessarily about the risk on final judgment, but rather discoveries and what would be revealed in terms of internal correspondence.
The only thing is that's a CNN Washington Post motivated issue. It's not an insurance related issue, and the insurance company gets to dictate the case. So it's you're in an unusual dynamic because you want your insurer to pay the indemnify you and cover you for your legal fees. Generally, the insurance company doesn't care what happens in discovery. Because I had some other people who wanted to bring suits on these kind of grounds in other cases and explain to them that discovery actually won't be a deterrent because the insurance company controls the suit. So they don't care if CNN's embarrassed during discovery. They only care about limiting the amount of money they write, the size of the check. So they usually look at the cost of defense. And they say, what's the cost of defense versus the risk that if we pay these people out, somebody else will come along and we'll get 10 more lawsuits like it. I think that latter risk is what would have reduced the risk. I think the settlement, if I had been in Sandmann's counsel's position and my goal was a monetary settlement, I would have made a settlement offer below the legal cost of defense. If the goal of my client was to get a settlement and use the power of the settlement to motivate people to publicly change rather than recover financially. I don't know what his motivations were, but I could envision that kind of scenario as being true.
Well, I would think, because I was thinking about this over the weekend, the flip side might have been that the insurers saw the internal correspondence and said our exposure is now X what we thought it was before, so we might want to settle for a little more than what we thought originally.
At least my experience with media insurance companies, They don't think that way. Their sense of, if anything, they badly underestimate their risk all the way through. They usually won't write a check for anything, even in bad fact patterns. But it's the reason is if you research jury verdicts, very few, they almost never get hit. So usually a very aggressive defense works. One of the few cases I've seen them write a big check in a case that I thought was bogus, but there may have been something else going on, was the show, and this will be probably another episode down the road, To Catch a Predator. There was a crazy lawsuit brought. NBC apparently wrote a big check and ended the show. No major media network has ever done a show like that again, even though that show exposed hundreds of would-be child predators. And that settlement happened around the same time Epstein was getting a sweetheart deal in Florida. So there's all kinds of allegations about what really took place there. But outside of that case, mostly they just don't write big checks, no matter the facts. That's why you'll see defamation cases go much longer typically than normal. So usually the checks are small. That doesn't mean the political impact can't be substantial. It just means that it's hard to get an insurance company to write a big check in a media defamation case unless you have very unique facts, like Richard Jewell. But Jewell, there's a good example. Jewell's settlements were ultimately publicly disclosed, and all of the settlements combined, between all the different parties combined, he only got $2 million. And he only got like $200,000 out of that after costs and everything were done. So there's tons of people who completely took a hero, made him look like a murderous villain, lied in the most ruthless way possible, did the most damage possible. And all of them, NBC wrote a check for like $400,000. So that gives you an idea for the range, what they're used to. If they're going to write $400,000 for Richard Jewell, are they going to write $1 billion check to something else? No. So it's hard. Unlikely.
Only if there was some smoking gun of an email or something inside that they knew they had to get rid of quickly. Okay, very interesting. And I do suspect, incidentally, also for people out there, they oftentimes have penalty clauses in their settlements, whereas if Sandmann does talk, he can lose a substantial portion, if not, a big portion.
And the other way around. If I've had settlements where there was a very low amount of money, but I wanted the impression to be otherwise, I demanded the confidentiality to give off the impression of a substantial settlement because I wanted the deterrence that would create by the impression of a big settlement, even when the settlement was actually very, very low. So both sides can have motivations for confidentiality.
Very interesting. And now we got Elizabeth Karen says, well done, Viva. Always enjoy the discussions. Keep up the good work. And let's end it on this because I was actually curious when I saw a comment to this effect before. Cernovich today put out a tweet that didn't say if, but when Trump loses, there will be X, Y, and Z. Franklin Basil says, Barnes still bullish on Trump re-election. Question.
Yes. Going back, I thought his greatest mistake was going along with the lockdowns because it would remove the economy as his trump card. And that has turned out true. As he's gone from +10, +20 approval on the economy to basically dead even. And so now he needs the economy to rebound in order to win re-election. And there's a substantial risk that does not occur. So before the lockdown, which produced the economic decline, particularly in working class circles and segments, I thought he had a 90-95% chance of re-election. I still put it at 2/3 currently. Joe Biden is still the sign of weakness for Trump will be if the Democrats replace Joe Biden with somebody serious. Governor of Montana, kind of serious, but that's not going to happen at this stage. So by historic metrics, as I think it's Norputh or Normuth, I always forget his last name, 91% chance by a leading political scientist who's been doing this longer than anyone, who has predicted 25 of the last 27 presidential elections correctly. And by historic metrics, Trump would win. But we are in unusual times. He has unusual opposition from institutional deep state actors, unlike anyone other than maybe Jimmy Carter, 1980, and has a degree of opposition from the press that's even exceeds what happened to Reagan or Nixon, in my view, and is facing a pandemic and the policy response to that pandemic that has produced an unprecedented economic reaction. So those are three unknown variables that are difficult for him to overcome. But by historical metrics, he will win re-election. So I'll stick with my historical metrics for now. I will be betting on him right now come October.
Okay, good enough. And let's do this one. There's a few more super chats. I'll try to get them out now. Notice Druid says, I asked this earlier, but what's Barnes' take on California SB 219 requirement of gender pronouns clause? Is it constitutional?
We'll have to save that for another episode because I'm unaware of that statute. Another crazy California law.
Well, and there's no question about it. There's going to have to be a breakdown because there will be a lawsuit, or we just break down the provisions for a topic for another date. And Taylor says, is it Barnes' impression that there are enough good people still in our legal system to hold the line, or are the numbers with the Marxist mindset too much? Let's just say good versus evil. Are there enough good people to keep this from being fundamentally corrupt?
Well, yeah, I have friends and family that are in the judicial system and they're in the legal system. A lot of judges will, you have good judges, bad judges, and political judges. The political judges are a mixed bag depending on what how they read the political environment. There's enough good people to maintain a good justice system and to continue to improve our justice system. So I always have confidence despite the obstacles.
All right. I don't see when someone accuses me of bias, I genuinely don't know which way they're accusing me because I get accused of it from both sides.
Yes.
Joshua Cornelius says, Washington team of friends, WTS. Last thing, because I didn't get to it, Man of Culture a while back said, what about clearly fake guns like the Stormtrooper? Cosplayers shouldn't be charged for reprimand for such a clear moment of incompetence. It's a high burden even in Canada to overcome, and there will be no incident. There will be no. I don't think there's going to be any.
That's a context in which they should know the gun is likely fake. So when someone's dressed up on Star Wars Day as a Star Wars person, they're probably not carrying a real AK-47. They're probably not carrying a real gun, and especially when it looks like it may be a Star Wars toy gun, maybe it is. And that was a ridiculous overreaction. It's sad. There's been a bunch from Canada, so Canada's been a little crazy lately.
Pepper spray in the Tim Hortons. The amazing thing about that Stormtrooper incident, I posted a picture of the only weapon that apparently looked like that Stormtrooper weapon. And within 30 seconds, people online were like, that's not that military weapon from 1915 because people are amazingly perceptive who know what they're talking about. And they're like, yeah, no way that Stormtrooper looks like that weapon. But at the end of the day, look, the cops have got to protect the public. And if there's the slightest risk, they go in and tell someone to get down on the ground who can't bend their knees because they're wearing a Stormtrooper outfit. But it is
that was like a context. That was where know what day it is, know what the outfits are, know who it is. And that usually tells me bad training because good training will have gone through that kind of distinction.
There's no question. It's also just a world on edge. Anything can be justified when everyone's on edge. Or at the very least, whatever. Everyone is on edge, and you can't predict what people are going to do.
No doubt.
Robert, let's wind it up now. Everyone, thank you very much for tuning in. This was yet again another live stream, and we almost went to 2 hours. And I think I don't hear noise, which means they might have fallen asleep, but doubtful. Robert, thank you very much. Stick around. We'll say our goodbyes afterwards. Everybody, thank you for tuning in, and we'll do it again next week.
Yeah, next week we'll have a potential U.S. Supreme Court petition I may be a part of concerning the ability to whether state courts can punish you for your speech outside of court, which just recently happened in an Alex Jones case. So I may be taking that up to the U.S. Supreme Court. But the good issues either way. I may or may not be involved in it, but it's a dangerous pattern when courts start punishing people for their speech outside of court by using their control over a case they have before them.
That is a very good question, which would have ramifications on employers' ability potentially, I imagine, to terminate for what their employees do and say on their own time on their own social media.
Yep.
Very interesting. We'll see where it goes, but definitely we're going to do this again next week. If it's not next weekend, I'm supposed to be on a road trip. We'll figure this out. But
no problem.
Robert, thank you very much. Everybody, thanks for tuning in. Have a great week.